Mr. Grayson has no violent history whatsoever. This is a 30-year-old man who has no history of violence on the job, off the job, at any time. There is no evidence whatsoever that he's ever engaged in anything like this previously. It is relevant that he's a member of the community and he owns a house with his fiance, that he served in the military. And these are all things that show that he's a member of the community, somebody who's not looking to violate any conditions of release. And crucially, he's cooperated with the investigation and the prosecution of this case from the beginning. He cooperated completely with the Illinois State Police report.
In a lot of cases, those limitations or problems would not be an issue, but they are an issue in this case due to the nature of the offense, which is a fatal violent offense. But also, as the circuit court pointed out, this was an offense that occurred right next to a law enforcement officer. And the defendant says, I wasn't deterred by that, I didn't think about it, I was acting in the spur of the moment. Well, if you act in the spur of the moment and you're not deterred by a law enforcement officer literally standing next to you, you can't come to court and say you will be deterred by a system that just keeps track of your GPS location. Specifically, he doesn't challenge the finding that the evidence or presumption is great, that he committed a detainable offense, meaning the first-degree murder of Miss Massey. Importantly, he also doesn't challenge the finding that he currently poses a real and present threat to the public. The only thing at issue is his challenge to the circuit court's finding that no conditions of release would mitigate the threat he undisputedly poses. The circuit court got this exactly right. The evidence does show that conditions of release would not be enough.